Mr. Chavez, this case, the state is just asking that it be dismissed or requesting a dismissal without objection from your defense attorney for a missing witness.
A jury trial is set, the courtroom is full, and the very first move is a denied continuance. Missing attorneys, scheduling conflicts, and pressure from every direction. This case is already on edge before testimony even begins.
All right, court is calling 2023 CR 0990, State of Texas versus Dean Villarreal. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jay Norton and Nico LaHood.
All right, this is scheduled for trial today. I have read defense's motion for continuance. Motion for continuance will be denied.
Well, Judge, I mean, Jason, as you know, from the continuance and from the last setting is in Caldwell County, and he's the lead on this case.
Okay.
So he's leaving tomorrow to Philadelphia. He's one of the adjunct professors for St. Mary's. I think you're aware of that as well, Judge.
Yes.
And so he's the coach for them. And so he's not going to be available. He has a letter on file for some time now. And then Monday, obviously, not obviously, but I think he told you he'll be traveling with a colleague and a friend to the Mayo Clinic. He's in some cancer treatment.
Yes.
And so he's not available, Judge.
Yeah. No, I understand. But with regards to the mock trial that he's having in Pennsylvania.
It's not he's having it, St. Mary's.
Yeah, I know, St. Mary's, and he's supervising or coaching. I have already previously told him that the court is not going to grant him for continuance to coach a mock trial team. This is an old case. I was going to make allowances for the issue with the medical issue, but jury's out in the hallway, so motion for continuance is denied.
Well, Judge, he's not present, so I'm not sure exactly.
He needs to be here, and I told him when he was here before that he was supposed to be here.
There is an additional issue. We tried to, someone from the office tried to view the CAC video last week and was unable to because the state's copy was broken. So as we stand here right now, we have not seen the CAC video as well.
All right, so you all need to watch it.
And for the court's knowledge and for the court's edification, I have never read Mr. Villarreal's files. I will be completely unprepared to try this case to the detriment of Mr. Villarreal, and he is definitely wishes the court to know that he would like to exert a Sixth Amendment right to the counsel of his choice, which is Jason Goss.
All right, so Mr. Goss needs to be here. Motion for continuance is denied.
Well, just so you know, Judge, he's in Caldwell County, so he won't be here for some time because it's a specially set sentencing, just so you know.
Okay.
Way predates your second.
All right, thank you.
Okay, Judge, we'll let him know.
All right, thank you. All right, you're up for jury trial today. Is there a motion for continuance?
Yes, ma'am.
Same issue, Judge.
All right, could I see the motion? Because I don't have it in the court's file for award.
Oh, sorry, wrong.
All right, court is calling 2022 CR 7666, State of Texas versus Stephen Ward. If I gotta have parties announced for the record for the state,
Brittany Mitchell for the state.
for the defense.
Jay Norton and Nico LaHood.
All right, and are you Mr. Ward?
Yes, Your Honor.
All right, this is scheduled for trial today. Defense, you filed a motion for continuance?
Yes, sir.
All right. And the court has reviewed the motion for continuance. The court will note that a previous motion for continuance for the defense was granted on August 8th. And motion for, after reviewing defense's motion for continuance is denied.
Judge, there's an additional issue that I understand from Mr. Goss, who is familiar with the case, and that they are still lacking CPS records availability. And I spoke with Brittany.
I think last time we were here, we were just waiting for the order to reach the judge's desk to sign it.
All right, so everyone needs to stop with the waiting for the order to reach the judge's desk. The court has not been presented with any order for CPS records. If the court were presented with orders for CPS records, the court would sign the order for CPS records. So state, do you have the CPS records in your possession?
We do, Your Honor, and I have signed, defense had done a DocuSign and I signed it last week. So I don't know if what we signed ever made it to you, but I do have a secondary one that I can.
All right.
Today.
turn it over to the court.
Okay.
Court will sign it. Motion for continuance is denied. Hello.
Good morning.
Good morning.
There's already a meeting.
Yes, so you're up for trial. So I just wanted to make sure you all were ready.
Actually, Judge, we were given some Brady material just yesterday from a witness that the state visited with, that we actually had asked them to do that, and they did. And they gave us some, what we think is exculpatory evidence. A witness who has information about the case, who doesn't believe that the offense occurred.
All right, can I see the file on Juan Tehran? And if you all could slide.
Yeah, I remember from yesterday.
Well, your client could stay in the middle. All right, state. So defense is saying that they just received Brady material? Or what they
Well,
deem to be Brady?
Yesterday, defense told us about a witness. They said this witness was gonna say the complainant, they knew of a lie the complainant had told. I called the witness. They said they knew of no such lie. They just had some assumptions that something she said wasn't true, which is not what they told me. I did provide them with notes of that conversation, which I guess is what they're calling the Brady information. They also told me they hadn't contacted that witness themselves. I'm not sure if they've contacted that witness since. But the state did contact that witness the same day they provided the contact information.
And Judge, just so it's clear, some people are just more willing to speak to prosecutors than to defense lawyers.
Okay.
And that's why we suggest that the state contact them, and that's.
I know. Well, here's the thing. I think all the attorneys in Bexar County know each other. Half of us ended up going to St. Mary's. I do not think or believe that the prosecutors in this court or the defense attorneys that have come before me are doing anything that's not above board. So if you all would like, because to talk to this witness together on the phone, you're more than welcome to do so.
The
That's
state
what-
has no further need to talk to this witness.
Okay.
And we have what we need from them, Judge. What I'm saying is we need to follow up on information that we got and see if it produces any other witnesses, and pin her down on that issue about why, whether in fact she thinks there's a lie or she has basis to believe there's a lie. It's not a minor point.
All right. So if you all are asking for a continuance, you have to file a motion.
I'll put it in writing, Judge.
All right. So, and that'll need to be heard this morning.
I'll put it in writing and
Okay.
I'll be here all morning.
All right. Thank you. Ready?
Judge, interpreter's looking up some equipment right now.
Okay. All right. Thank you. Always good to see you. Look at you wearing the purple LSU color. I appreciate that.
Just for you.
All right, state. There would not be any favoritism because he's wearing an LSU color.
Thank you, Your Honor.
Good morning.
Good morning. Always great to see you. How you doing? Oh, you're in purple as well, with a splash of pink. Those are my two favorite colors. Court is calling 2022 CR 10113, State of Texas versus Rolando Gutierrez Chavez. Can I have parties announced for the record for the state?
Travis Banks for the state of Texas.
Defense?
J.D. Garza defending Mr. Rolando Chavez.
And are you Rolando Gutierrez Chavez?
Yes.
All right, we have an interpreter here. If you could raise your right hand for me. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
Any relation?
No relation.
All right, I always put that on the record. All right, the state has filed a motion for continuance. Defense, are you in receipt of the motion?
I am, Your Honor.
All right, do you state, what is your reason for the motion?
The material witness who was a witness to the offense has been unreachable by the state. The state's made different attempts to reach her. We've looked for alternative contact information to reach her. And thus far, the state's been unable to reach her, and the state is moving for continuance for more time to find this witness.
All right, defense.
Your Honor, as court knows, my client really needs a speedy trial. The fact is that under 2903, the state needs to establish what due diligence they have gone through to try to find this witness, especially since it's a material
No,
witness.
I'm aware of the law.
So, just putting it on the record,
Mhm.
because that's the reason why we have to object to this.
Okay. All right, motion for continuance is denied.
Your Honor, the state has another motion.
Yes,
May I approach?
yes. All right, the state is tendering a motion to dismiss for missing witness. Any objection?
No objection.
All right, we can go off the record. Mr. Chavez, this case, the state is just asking that it be dismissed or requesting a dismissal without objection from your defense attorney for a missing witness. So what that means is they're not saying they're dismissing it because the actions did not occur. They're saying they are dismissing it because a witness that they need to prove their case is not present. I don't know anything about the facts of this case, but what I do know is you know what brought you here. And if you don't change certain things, you'll be back again. Do you understand?
Yes.
All right, good luck to you. Counsel? Oh, we'll walk around. Hey, Travis. People always try to.
Jose Marie Cavazos.
All right, so I do remember this case, although I don't have any documents before me on this case.
Yeah, we are,
Jose Marie
Cavazos.
Marie Cavazos. Is this the case where we're waiting on something?
This is the one where my client is in El Paso
Mhm.
and we're trying to get a buckle swap to do an Article 64.
All right, so where are we on that?
Well, the last time we were here, we were going to bench warrant because everything else had failed. We tried to go through the public defender's office in El Paso.
Mhm.
We have tried to appoint investigators. Nobody will touch this because of the chain of custody issues.
Okay, and yes, and I cannot legally
Right.
bench warrant him because I don't really have jurisdiction. He hasn't done anything to warrant a bench warrant.
He doesn't have a case open. He's
Yeah.
actually out on parole, and that's part of what our problem is. I had checked with Ms. Ferguson earlier, a couple weeks back, and that was kind of the understanding that I got. I tried to wrap my head around this and try to figure out what tools we do have. The only two things that I think we can maybe do is issue a KPS or do a writ of attachment.
All right, let's do this because the writ of attachment is off the table
Okay.
for legal reasons. How far is El Paso from San Antonio? Help me out here with my, if I were in Louisiana, I would tell you how the distance between the parishes. I know I've been here long enough where I would know, but I do not know. Somebody from the audience, how far?
60 miles. Thank
All
you,
right.
sir.
560 miles.
All right.
So it's a little bit longer to drive from here to Shreveport than from here to El Paso. So does he have transportation to get to San Antonio?
My understanding is that he does not.
All right, Greyhound bus. Is that possible? Do they have, I know they have Greyhound in El Paso. Well, I know you'll stop in every small town.
My trick is this, is that this was a sex offense.
Mhm.
He's currently kind of in a halfway house,
Mhm.
trying to find a place to be able to live. All the places you have, it's got a bus stop too close, or there's a school too close, or there's something is prohibiting him from being able to get a place.
Is there not a professional place?
You would think, honestly.
Do we not have any DNA laboratories that will go to do a buccal swab and come back? I will see
I've
if,
tried LabCorp. I've tried, there is no place in El Paso that will do it. And they flat out tell me, we're not going to do it unless an El Paso judge orders us to. That's the pushback I'm getting. It is ridiculous. And now I've got a PO, a parole officer that I don't know. I've got to coordinate that too to get him to travel.
okay, so request a test, and mind you, I'm just Googling online. Request the test. Order your test. Oh, this is one where they order it and you do it yourself, then send it back in. But they say they have a laboratory with over 3,600 locations. And you're right, it's LabCorp and
And I've contacted them and I've tried to get them to get on board with this. That was one of the places that we were trying to go through when we were trying to get the public defender to do it.
all right, so let me ask you all this. Are you all available to come back on Friday?
Friday this week, no good.
I
My
probably
day.
won't either. I will be in here on Friday or on Monday.
Are you all able to come back on Monday?
No, not on Monday, Judge. We can come back another day next week if that works.
All right. You all decide, confer with each other, decide what day next week you can come back. And I'm going to solve this problem. So this is what I need to solve this problem. One, does anybody have any objections to me solving this problem?
I have no objection, Judge. I need all the help I can get.
Okay,
As long as it's within the parameters of the code, Judge, which I know you're already
Yes.
thinking about those things. So yes, as long as it'll be kosher, which chapter 64,
yes.
that'll be fine.
So this is what I need to solve this problem. I'm going to need to know specifically where he's located in El Paso,
Got that?
some contact numbers there if you have them,
Got that?
and the name and date of birth of your client.
I'm sure I've got that.
All right, so if you all give that to Norma, and on the handwritten item that you give to her, if you're right in there, this is to be done by this date, the date that you all come back, and I'll make sure it's done.
Okay,
This
Judge.
problem will be solved.
Thank you.
If we all have to do a road trip to El Paso.
You're flying.
All right.
Southwest.
All right, thank you all.
Thanks, Judge. Appreciate
Sure.
it.
Pete Garcia.
By the end of this docket, continuances are denied, a case collapses over a missing witness, and the judge makes one thing clear. Courtrooms run on preparation, not excuses. If this breakdown kept you locked in, hit like, share your thoughts below, and subscribe for more real courtroom moments.
2022 CR 3998, State of Texas versus Jacqueline Wells. That party is announced for the record for the state
Daniel Escobar for the state of Texas.
defense.
Joseph Statson for Miss Wells.
And are you Miss Wells? All right. And Mr. Statson, when were you appointed to represent Miss Wells?
I was appointed today. I explained that to my client that she had 10 days for me to prepare for any hearing. And we both agreed to waive that notice of appearance, waive the 10 days notice.
All right. Ms. Wells, do you wish to continue? All right. And you understand that your attorney does have 10 days to prepare?
Yes, ma'am.
Right. And knowing that you wish to continue with the motion to revoke? All right. You need to speak up. All right. I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. And First Amendment motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Jacqueline N. Wells who was placed on deferred adjudication in 2022 CR 3998 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram on July 7, 2022 for a period of 2 years? Is that you?
Yes.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Jacqueline N. Wells, did then and there fail to report to the supervision officer as directed for the months of November and December 2022 in violation of condition number 4.
How do you plead to that? True or not true?
State waives all the violations.
Any objections?
None.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? I'm sorry, number 4? Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor. The agreement is for the motion to be granted and for revocation and for 10 months in the state jail facility.
All right, is that the agreement?
It is, Your Honor, and we would ask that all her back time credit apply. She has 139 days credit.
Okay.
And then the state's also going to take into consideration NIMAG number 713316.
All right, Ms. Wells, are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am. Yes, ma'am.
All right, I have a few questions for your client.
Yes.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? right, you can lower your hand, state your name for the record.
Jacqueline Wells.
All right, Miss Wells, where have you been?
Have I been, I've been in Bear County.
No, I mean, you haven't been doing your probation. Why not? What's been
Okay,
going on?
I know last time that I came, I was supposed to be going to Sativ. That's what you recommended. And whenever I was waiting for my treatment bed in jail, Bear County, I wasn't aware that, I just got released without any paperwork. So I don't know.
And so you got released and you're, oh, happy day, I'm released and I'm just going to live my life.
Honestly, I thought that I had just gotten time served or something. I didn't understand why I just got released, but I thought that I don't know. I just know it wasn't Sativ, so. Other than that, I just.
Okay. So I want you to be honest with me, okay? I'm looking at following this plea bargain agreement, but I want to know some things about you. And then, depending on what you tell me, I will probably give you a choice, okay? But the 10 months will definitely be one of those choices. So do you have any children?
Yes.
And how old are they?
One is 15 and the other one's 9.
Right, and where are they?
With the dads.
Okay. And was Child Protective Services involved? And what drugs have you been using since you were released?
Since I was released, meth.
Meth?
Alcohol.
Okay, meth and alcohol. It appears to the court that you have a drug problem and you need to have that drug problem taken care of. Otherwise, you know what's going to end up happening? The last time you use may be the last time you use, and then your children will definitely not have their mother in their life. You still have a chance, maybe, if you get yourself together, if you get clean and sober, you may still have a chance to be in their life. But you must be clean and sober. And the fact that you were released accidentally or whatever happened, and you've been using, I appreciate your honesty telling me that you've been using. That tells me that you need help. So if you would like, I can send you to the state jail facility for 10 months. What's going to end up happening is you're going to go to state jail facility for 10 months. You'll do your time, you're counting off on the calendar, and you are going to get back out and you will use again. Or I can continue you and I'll continue you and I'll have you placed in an inpatient treatment or either see if felony drug court would accept her or wants her. Have you ever been to felony drug court?
Mm-hmm.
Those are the choices I can give you. So if you want to do your 10 months, I will follow that agreement, but you know yourself better than I do, better than your attorney does. But based upon your track record, when you get out of jail or state jail facility after counting your 10 months off, you're going to go use. You're going to go be with whomever you were with before who's using with you. And you may end up dying from that. You understand? So if you want a chance to be clean and sober, to be the person you were meant to be, not the person who's picking up criminal cases, not the person who's using, then I will give you that chance to do that. So what would you prefer?
The chance.
Okay. All right. So what we're going to do,
Your Honor, may I?
yes.
So I just want the court to be aware that she wasn't actually let go erroneous or anything like that.
Mhm.
She was disqualified from status.
Okay.
So she had medical issues that prohibited her to actually go to status.
Yes.
So in looking at the case, the modifications were after status based on her previous NTR. This is her third NTR.
Okay.
So based on previous NTRs that we've had, the modifications the last time was to do status, and then after that, a felony drug court. So if Your Honor would like, we can just move forward with the felony drug court referral, see if we could get her the help that she needs.
All right. We're going to then, if both state and the defense are in agreement, I will deny the motion, alternate amend conditions. You'll be referred to felony drug court. You're going to remain in custody. And Mr. States, and if you can contact felony drug court and let them know that she really needs the help and she wants the help. But when they come and interview you, you must really let them know that you need the help, because I know they're getting close to probably reaching the number of persons they can have there. Do you understand? All right. So what I'm going to do then.
And I apologize, ma'am.
Yes, yes.
It does state that she expires in July of 2024, so.
We'll extend her. Yes. So I'm going to extend you, and I'm going to extend you for 2 years. But the nature of your case, it's not a case where if you complete everything that you can't be terminated early. And normally in felony drug court, if you complete everything and you complete their program, they will allow you to be terminated early. Terminated is not a bad thing on the criminal side. It's not like the
Early discharge.
yes, it is not. What's the name of the movie with Arnold Schwarzenegger?
Terminator.
Terminator. It's not the Terminator. So you will not be terminated in that way. It will be a good way. So I'm finding violation of condition number 4 true. I'm going to extend her for 2 years, and we'll do a referral to felony drug court. And that's to take place while you are in custody. And if for any reason you get released, you know you're not supposed to be released. So if you are accidentally released or something is not right with the paperwork and they release you, you know what you need to do? Come straight to this court right away and say, Judge, I've been released and I know I'm not supposed to be released. You understand? All right. So this is your chance. You need to take it. All right. Is there anything else from either side?
No, Your Honor.
If she does not qualify for felony drug court, would you like clients here?
Yes. If she doesn't, if she's not eligible, then bring her back here from the jail and we'll figure out what to do. And we'll keep Mr. Stetson, if you could make sure that you follow through till she's accepted.
Yes, Your Honor.
All right. Thank you. Is there anything else?
Nothing, Your Honor.
All right. Thank you.
Thank you, Judge.
You're welcome. 23 CR 1646, State of Texas versus Mark Anthony Wilson Jr. Can I have the parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
I'm your memorial, Your Honor.
And are you Mr. Wilson?
Yes, ma'am.
Are you the same Mark Anthony Wilson Jr. who was placed on community supervision in 2023 CR 1646 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on June 13, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 41 on or about the 7th day of July 2023 in Bexar County, Texas, the defendant Mark Anthony Wilson Jr. Then and there refused to participate and comply with the rules and regulations of felony drug court in violation of condition number 41.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 41, court could find it true, grant the motion, and sentence you up to 4 years in prison? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court will find violation of condition number 41 true. Is there an agreement?
No, there's not.
All right. Is there anything you wish to say on behalf of your client?
Yes, Judge. Judge, in this case, Mr. Wilson asked the court to follow the probation's recommendation, which is granting him, putting him back on regular probation rather than, I believe it was drug court. Yeah.
All right.
Felony drug court. So we'd ask the court to just put him back on regular probation, rather.
All right. Probation. Has Mr. Wilson played the restitution, or was there restitution order for the drug testing?
He's been in custody on it this entire time.
All right. All right, Mr. Wilson, the court always gives people chances. If they want help, the court will provide help for them. If they don't want help, sometimes there's nothing I can do. Court is finding violation of condition number 41 true. Court is going to grant the motion. Court is going to revoke you, sentence you to 4 years in the prison, give you credit for any time served. Going to show you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it? All right, you have a limited right to appeal that is as to the allegations in the motion, not the fact that you're on probation. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Mhm.
All right, we can go off the record, Mr. Wilson. When I send people to felony drug court, it's because they have a drug problem. People are not allowed to write their own programs. If they could write their own programs, they would not be here. So you had a chance to be successful and you chose a different path.
Man, I didn't get a chance at anything but the most extreme. There's no lifetime, there's no nothing.
I'm
And
sorry, I can't understand what you're saying. What did you say?
I never had a chance at lifetime or anything else. We jumped straight all the way to the most extreme. And I kept getting promised I would get out if I did this. I would get out if I did this step. I would get out if I did this.
No,
step. And I
felony
never
drug
got
court
out.
is not extreme. Felony drug court is if you would accept it, felony drug court, then they would have been in charge of your conditions of probation. If they felt that you should be an inpatient, you would have been an inpatient. You chose not to participate. You said you don't want to be on there. Here's the thing. You do not get to choose your own plan. I don't know why people think they get to choose what their conditions should be. I'm in charge of setting conditions. I'm in charge of your length of probation. And I sent you to felony drug court and you chose not to participate in felony drug court. Therefore, you're going to prison. If you would like, I could refer you to the therapeutic community. Whether or not they accept you in the therapeutic community is completely up to them because I have no jurisdiction over that. So if you would like that, you will still have to request it for them. Do you understand?
Yes, ma'am.
All right. Good luck to you.
Maybe excuse Judge?
Yes.
Thank you.
So here's the bottom line. One defendant gets a treatment-focused lifeline through felony drug court, while the next one loses that chance after refusing to follow the program's rules, and the judge revokes to prison time. If this had you shaking your head, hit like, share your take in the comments, and subscribe for more real courtroom breakdowns.